you know, that people don't print obituaries like they used to.
Yeah.
I mean, unless you're in the same church or group.
Right.
I think that's it.
I think it is too.
December 23, it was 4 or 5 months ago.
Yeah, I wouldn't have.
Well, that solves.
That does solve it, doesn't it?
Mr. Gold can now resume trying to keep the bar down on Memphis.
Trying to do that.
He's trying to keep the bar Durham on Memphis. You know, Bart Durham was the Morgan in Nashville. There, I was going up there. Mr. Gold's from Nashville, I knew that. Did he?
Yes.
Who? Wait a minute. Okay, I thought he was from Nashville.
He moved there, I think, after he started practicing.
I've never had a,
He had some issues over there, actually.
I know that, but I've never had an exact conversation with him that, we always seem to be at odds, but I'm a really very pleasant person to be at odds with, so I don't take anything personally.
He's an interesting character.
He is.
I'll give you that.
There's nothing like an interesting character.
Yes, exactly.
Man, I'm so glad you said that. I can close that file.
Really, it's funny.
All rise. This Honorable Court of Appeals of Tennessee is in session. Please be seated.
Good afternoon and welcome to the Court of Appeals. Appreciate y'all being here. I want to take just a few moments once I get everything set up here and talk about our procedure for a moment. And a few other things, first of all, I know everyone's an experienced practitioner, but I do want to basically touch base about the procedure we utilize. Each side gets 15 minutes to make its oral argument, and if you're the appellant and you wish to reserve any rebuttal time, the proper procedure to do that is to request that after you've come up to the podium and introduced yourself, but before you begin your oral argument. You may reserve up to 5 minutes of rebuttal time. Appellee gets no rebuttal time. We have a lighting mechanism on the podium, and we believe it to be very straightforward. When you begin your argument, a green light will come on. As long as the light's green, you've got plenty of time. Once the light turns yellow, it just indicates that you're running out of time, and once the light turns red, you're out of time, and we ask that you please respect those time constraints. One thing that has become very important in the past year or so is that we are live streaming these arguments. Once we begin the arguments, it goes out immediately. So please think about what you're saying. If you don't get a do-over with that. Once you say it, it's out there. So please think about that. Ms. Angie, anything before we start?
No, Your Honor.
I do want to take a moment and introduce the panel. The panel this afternoon is Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. All right then, you may call the first case.
Berkeley Research Group LLC versus Southern Advanced Materials LLC.
Hear from the appellant.
I would like to reserve 5 minutes if I could.
5 minutes, all right, sir. You may proceed.
Good morning, my name is Philip B. Seaton, and I represent the appellant, Southern Advanced Materials, LLC, a Delaware corporation. I'd like to begin by indicating to the court that in review of the documents submitted by my opponent, especially in their brief, on pages 3, I think 29 and 30, it made reference to the fact that Southern Advanced Materials, LLC is a Tennessee corporation. This, of course, is a crucial fact in a jurisdictional argument, and one which, if true, would have indicated there would be no real chance of appeal. However, that is not correct. That particular entity is not the entity that was in privity or in contract with Southern CV Holdings, which is the entity in question in which all of these issues arose with BRG. And may I use the acronym BRG for Berkeley Research Group, Your Honor?
Sure, go ahead.
I would ask the court to make special notice of document number 30 in the trial record, and document 57. Document 57 is a filing information sheet from the Business Division, Division of Business Services, Department of State. And it clearly shows on the filing descriptions that on 2/4/2003, the Tennessee LLC, Southern Advanced Materials LLC, Tennessee, was dissolved and had its license, it's been revocated because of a revenue issue.
Is the entity that's before us today Southern Advanced Materials LLC?
I'm sorry, sir.
Is the entity that's before this court, does it go by the name Southern Advanced Materials LLC?
It does.
Okay. And that's the entity that's the respondent in this lawsuit?
That is the entity, but the entity which is the entity in this litigation, that is a litigation with BRG, is the Delaware LLC, Southern Advanced Materials LLC. There was a Tennessee LLC of the same name, but that was revoked, and it is not the document, that is not the LLC, which is the LLC that contracted with BRG for its services.
Does the LLC that contracted with BRC, does it have any contacts with Tennessee?
No. It's a Delaware LLC. It was the Delaware LLC that was involved in the litigation, which it was the plaintiff, where Robert Abrams, who was the principal of CV Holdings, was the majority shareholder and the defendant. And Berkeley Research Group was actually retained by the Delaware LLC to prepare an expert report validating the Delaware LLC's expert on damages.
Well, the office that was located at 5100 Poplar Avenue in Memphis, was that?
That is an office, correct?
Is that an office for the LLC that you represent?
Yes, the Delaware LLC.
The Delaware LLC?
Yes.
So it has an office in Memphis?
It had an office, administrative office in Memphis, that is correct.
Okay.
But the litigation, I apologize, the contract with the BRG was between BRG Delaware and Southern Advanced Materials Delaware. That is the contract, which is the subject to this particular dispute that was, has arisen today.
Well, my question to which you said no was I asked if there was any contact with Tennessee For the Southern Advanced Materials LLC Delaware that you represent, you said no, but you have an administrative office in Memphis.
That's correct. I'm sorry, I misunderstood your question, for which I apologize. What I meant to say was the Delaware LLC was the contracting party with BRG. And
I don't understand
the significance?
significance of that, other than the fact, I agree, assuming that's correct, and that same LLC has an administrative office in Memphis, I don't see how you can say there's no contact, and why, what,
Well, I think, Your Honor,
What's the argument?
I understand your point. So what I would say to you on this is this. What I'm saying is, in terms of contact, minimal contacts or special contacts, the only relationship to the contract between BRG and Southern Advanced Materials is the contact of those two Delaware organizations outside of anything done in Tennessee. There is an administrative office, but it's just for administration. But what Berkeley Research Group did for the Delaware LLC was to prepare an expert report based upon the litigation which was pending between Southern Advanced Materials and Robert Abrams in New York. That was their commission and their only commission.
is Southern Advanced Materials LLC, the Delaware corporation, licensed to do business in Tennessee?
I can't answer the question, I don't know. That
Do they have an
license to-
agent, do they have an agent for service of process in Tennessee?
Yes. I can answer that question.
Go ahead.
So the misidentification that you started your argument with, is that something that the trial court was presented to the trial court, and did the trial court make that determination? Or did the trial court say that these are the same entities? Or was that even an issue in front
That
of the
was,
trial court?
those documents I referred to were presented to the trial court, that is correct.
And did the trial court make some kind of determination about those documents?
To my knowledge, I do not believe the trial court directly addressed that issue.
Okay. Was this argument made to the trial court?
It was made through the paperwork and the certificate and the affidavit of Mr. Wells, when we presented to the trial court the fact that there had been no contact between Berkeley Research Group and Southern Advanced Materials, but for the activities undertaken in the contract between the two parties, all of which occurred outside of the state of Tennessee.
Other than the
Yes, the administrative office, which I
contacts that-
apologize to Judge Golden for saying.
right, exactly.
So our point is here, that basically, when you look at the cases, when you see whether you have minimal contacts, BRG was hired specifically as an expert witness in the litigation in the Supreme Court of New York, filed by Southern Advanced Materials against Robert Abrams in connection with its contention that that defendant had not properly purchased the interest of Southern Advanced Materials, Delaware, and that as I said, the engagement was outside of and not involved in Tennessee. Rather, it was all done in New York, Washington, and Washington, not anything done in Tennessee of a substantive nature.
Why is that important?
I think it's important when you look at the cases about minimal contacts. I think it's important about the quality of the contacts. In fact, when you look at the Baskin case, they make special note that no one ever appeared in Tennessee in that case on behalf of the defendant, or did any work in Tennessee on behalf of the defendant. And that is the same, I think, analogy that holds true in this particular case, Judge, that in fact, BRG was always looking as a Delaware LLC at the work they were doing for the Delaware LLC in the venue of the Supreme Court of New York.
Were checks issued through your office in Memphis, Tennessee?
Yes, they were.
To pay on this contract?
Yes, they were. They were part of the administrative process of the company, but not the operational process.
And you don't consider any of those facts to be minimum contacts with Tennessee? The fact that you have an administrative office here, that you make payments on this contract from that office?
Your Honor, I don't think there are minimal contacts as required by the courts, because there's no indication that, to use the Baskin term, that my client would have been hauled into Tennessee in connection with a request for the adjudication of the rights under the agreement, which was the litigation connected to that agreement. And that what we intended or saw as happening would be, since they were in all Delaware law applied, that the appellee would then in Delaware file for its rights under Delaware law, consistent with the fact that all of the rights for both of the parties involved derived under that jurisdiction.
Thank you.
I have nothing further, Your Honor.
Yes, sir. You've got your rebuttal time. Hear from the the appellate.
May it please the court, Attorney Adam Nami is here on behalf of the appellee. And I'll just jump right into it, Your Honors. I think y'all picked up on the issue. The issue is one of jurisdiction. The issue is one of, I would believe, general jurisdiction, continuous and systematic contacts with the state of Tennessee. It's undisputed. Several things are undisputed. The first is...
Well, let me ask you a question before you get into that. I've reviewed the trial court's order. Trial court's order doesn't say a lot. What was actually in front of the trial court as far as, was there an evidentiary hearing or...
So here's the twist. I did not handle that matter at the trial court. Counsel named Jay Miller, former counsel.
We often hear that in this court, unfortunately.
What's that?
That I was not trial court counsel.
Well, there is a transcript from that proceeding. I believe the trial record volume 2 is the transcript.
Okay.
I believe these arguments were made. The transcript speaks for itself, but I believe these arguments were made. However, one argument that wasn't made that I'm hearing today is that we've got the wrong Southern Materials, and that's the first, or Southern Advanced Materials LLC, this Delaware versus some other entity. Once again, the record speaks for itself. The contract, the underlying agreement between Berkeley and SAM, it's part of the record, and it clearly is between Southern Advanced Materials LLC. That's who the party is. I don't know anything about Delaware or anything else like that. That's who.
This was an arbitration, right?
Yes.
There's no argument about the arbitration.
No.
This is just to enforce the arbitration.
Correct. This is a collection matter. And I would submit, Your Honor, I mean, my brief speaks for itself, but the judgment order, the arbitrator's order, was entered in accordance with Delaware law, choice of law. It's abundantly clear throughout his decision that he applied Delaware law to the disputes at issue. That judgment gets entered or awarded, and then basically what happened, it's a collection matter. In other words, we didn't get paid, my client did not get paid, so what they do, they went to enforce it as per the intent of the parties. The parties agreed to arbitrate, they agreed to use the JAM rules, and they agreed that language that I'm sure Your Honors are familiar with is, judgment can be entered in any court having jurisdiction thereof. Both the agreement and the JAMS, J-A-M-S rules provide that. That's what we did. We got checks from three separate checks. All this is part of the record, obviously, Your Honors. 3 separate checks that all had the 5100 Poplar address. That's where so naturally, in order to enforce, they went to Tennessee to try to file a petition in accordance with Tennessee law and the Uniform Arbitration Act. And I do think it's noteworthy that their own affidavit confirms they have an administrative office in Memphis at 5100 Poplar. I would submit the documents appear to indicate that presence has been there for 20 years. I believe Item, trial record 53 is the articles of organization for the company back in July of 2001, and they set themselves up as a Tennessee corporation. Now, they may no longer be that, but clearly they've got a bank account. They were served as well at 5100 Poplar, same address. The checks, once again, have 5100 Poplar. And I think what's also important is, as late as January or June of 2023, a garnishment was successfully attached on the bank in Germantown, and they got some money. I mean, so as late as June of 2023, this company, they're doing business in Tennessee. I mean, they're clearly doing business in Tennessee by their own admission. They have bank accounts in Tennessee. They have assets in Tennessee. We recovered some of those assets. Specific jurisdiction, I don't think that's, I don't believe that's an issue, but clearly general jurisdiction, the authorities require continuous and systematic contacts. We believe the evidence clearly supports such a finding. And even when you look at some of the factors for fairness, they apply as well. It's inconceivable they wouldn't expect to be hailed into court in Tennessee when they admittedly have an administrative office here. They've maintained a presence at Clark Tower, 5100 Poplar, Clark Tower for almost 20 years. They were served with process there. They've got a registered agent in this state. You know, I will take any questions that the panel has, but frankly, I believe the brief speaks for itself as far as, you know, personal jurisdiction, I believe is proper. Trial court acted properly in confirming the award. It's undisputed the parties agreed on a $12,000, $12,500 attorney fee, and we're here before the court as well because we believe that the contract clearly provides that the cost incurred in appeal are recoverable. So in addition to affirming the trial court's ruling, we'd request that the case be remanded to determine and to have a hearing regarding our fees incurred in appealing this matter.
Was that raised as an issue on appeal?
You know, I don't know. I don't believe so. Once again, I believe that the intent of the parties is what, getting back, the parties clearly agreed on it. What the parties didn't agree to is only enforcing an award in Delaware. I mean, the intent of the parties is that you can enforce that award in any state or federal court having jurisdiction thereof. Tennessee, we believe, clearly has that. We believe the facts in the record confirm that. And there's simply no reason why the original judgment order should not be affirmed.
Thank you.
Thank you.
May I now respond?
Yes, sir. You've got 5 minutes.
Yes, and I'll respond. I was frankly thrown off balance by the questions because that isn't the question of jurisdiction is one of the questions in this case. The primary question in this case was whether or not the language in the contract drawn by BRG was in fact language where the laws of Delaware gave complete control of the proceeding to actually be interpreted to mean that all actions should have occurred in Delaware, including the filing of an award given by the arbitrator. It's different than the jurisdictional argument. It's really a textual argument for the language.
Was that raised in the trial court as well?
Yes, it was. That was definitely raised in the trial court. In fact, it was what took up the most of the time in the trial court. The jurisdictional issues were raised in the trial court as well, Your Honor, so that the record's clear. I'm not going to say that they weren't. But what I'm saying is what our position is, the language that BRG put into the agreement which was executed by the parties gave they talk about control and interpreted and governed by the laws of Delaware.
Was that issue addressed by the arbitrator?
By the arbitrator? He ruled he was yes, in the sense that he handled the case.
Is that a question that this court or the trial court should have even addressed? That sounds like that's an arbitration question.
Your Honor, respectfully, and I don't think the arbitrator either had the authority to do so. He ruled in connection with Delaware law. All of his rulings were based on Delaware law, correct? And what we've argued is...
I don't understand I didn't understand your argument then. I'm sorry.
I'll try to rephrase it. I apologize. What I've said is this. We argued before the trial court that an award given to BRG should have been lodged in Delaware because the language in the agreement prepared by BRG was that Delaware law would control and be governed by Delaware law. And therefore, all activities undertaken, including the filing of the arbitrator's award for a final judgment, since all of that is part of a final judicial process coming to finality with the filing of an award of judgment to be enforced by the Delaware court. So we argued all of that should have been done in Delaware as opposed to having half or part of it done in Memphis because there was nothing in, but the argument made by.
Suppose there's nothing to execute on in Delaware.
Your Honor, you're wrong, there was.
I don't know if there is or not, I'm just saying.
No, there was, Your Honor. You had the award of the arbitrator based on Delaware law that could have been executed on.
I'm talking about assets.
Pardon me, sir?
Assets. Do you have assets in Delaware?
No.
I
But
mean,
we only had assets actually, except for the $31,000. The only asset we had was the litigation against against the defendant Abrams in New York. In other words, there were potential assets of millions of dollars. I'm sorry if you're shaking your head, I'm sorry if I'm not being clear, but I hope the panel at least understands my position on this. Thank you very much.
Thank you. Thank you. Thank you, counsel. We will take this matter under advisement. We appreciate your briefing, and we'll review the record and endeavor to get you an opinion as quickly as possible. Thank you.
Your Honor.
You may be excused.